What matter is it that you'd like to talk about?
Thank you, Your Honor. We believe there is a witness who may start testifying later today that defendants will call, and there may be some improper testimony offered, and I'd like to hand over to my colleague, David Giller, to explain.
Okay, Mr. Giller.
Your Honor, it came to our attention on Sunday that defendants intend to elicit testimony from Brian Neesby on the substance of an affidavit that he filed in a separate case nearly 6 years ago, the Curry versus North Carolina case. That affidavit, again, filed in that separate case and not refiled here, addressed the matching analysis that was done by the expert in that case, Dr. Stewart, who again is not a witness or an expert in this current case at the moment. The affidavit purports to address and analyze that matching analysis, which was not utilized here. But more importantly, and in addition, it also is an improper expert testimony where Brian Neesby has not been offered at any point by the defendants as an expert. He was disclosed as a lay witness. He was deposed as a lay witness prior to the beginning of expert testimony. At the deposition, Mr. Neesby testified that he is not being proffered as an expert witness. He hasn't submitted any expert or rebuttal case. And at no point prior to yesterday had defendants made any mention that Mr. Neesby would be testifying to this affidavit and in effect operating as an expert witness. Two other notes: that in the Curry case in 2015, it never went to trial, and Mr. Neesby never testified to these. And in the McCorrick case, where, again, they tried to belatedly introduce this exact same affidavit, there was, in fact, a motion to disallow it as improper expert testimony. And due to an agreement between all the parties in that case, Mr. Neesby never testified to any of the information in that affidavit. The affidavit is marked as a JX exhibit, and the reason for that is it is utilized or relied upon by Dr. Thornton, and such, as we discussed last week, we don't have any objection to it coming in as evidence that Dr. Thornton relied upon. However, we do object to any testimony being elicited by Brian Neesby of this affidavit from 6 years ago. We also have prepared a short motion that we can deliver to the court, extrapolating on the points I just made.
Okay, thank you. Response from the defendant.
Good morning, Your Honor. Nicole Moss for the legislative defendants. I would start with the point that Mr. Giller left off with, which is this affidavit is in fact already in evidence. Plaintiffs moved it in with the joint exhibits during their case in chief. So this testimony in this affidavit from Mr. Neesby is already part of the record in this case. It is a document that plaintiffs had and used, I believe, during Mr. Neesby's deposition. The information, and I can proffer that the information that we intend to ask Mr. Neesby about is not sort of expert testimony, but is testimony based on his experience, his knowledge, and the work that he does for the State Board of Elections, which has included conducting matching analyses, and his understanding about the data fields within the voter registration file and the Department of Motor Vehicle files that can be used for those analyses, and his views on which fields it would be important for an expert to look at if they were going to be doing a reliable matching analysis. Plaintiffs have offered into evidence information from, for example, Dr. Quinn, talking about a matching analysis that Mr. Neesby did in this case to identify voters to send a mailing to. And Mr. Neesby testified in his deposition about how the purpose of that matching analysis was not to try to determine what registered voters in fact lacked qualifying ID under the law that's being challenged here. And our questions of him are not going to be, asking him to review. I don't know that he's reviewed Dr. Quinn's matching analysis. He is an employee of the State Board of Elections. He's not our expert, but what he can speak to and what he has spoken to previously is if he were going to look at fields to match upon, what would be important fields to look at and what would be the consequences of not looking at some of that data in terms of coming to a reliable kind of understanding of who does or does not have a DMV issued ID. That is the limited purpose for which we would be offering information from Mr. Neesby, and we would only really need to use that affidavit to refresh his recollection. So I'm not even sure it'll ever need to even be used with him if he doesn't, just based again on his many years of service with the State Board of Elections. I think this is knowledge that he has, his own firsthand knowledge. Again, perhaps we might have to refresh his recollection, but that would be the purpose of using that affidavit. And so, very similar to the testimony that plaintiffs offered from Ms. Fellman, who was not identified as an expert, did not submit an expert report, but yet offered a great deal of opinion information on her views about voter confusion within the state. Mr. Neesby, we submit, will be offering information based on his firsthand knowledge, his work, his experience, and his knowledge of these databases. And so we don't believe that an expert report was needed in the first instance.
Your Honor, may I briefly respond?
Actually, could I be heard from the state defendants?
Yes, let me hear from Mr. Cox, and then Mr. Giller, I'll go back to you.
Thank you, Your Honor. Paul Cox from the Department of Justice on behalf of the state defendants. Just a couple quick points. Just to confirm, Brian Neesby, who is an employee of my client, the State Board of Elections, is the Chief Information Officer of the State Board of Elections. Your Honors will hear that it's his role to conduct matching analysis like the ones that have been described already this morning. He is, and also to confirm, he is not being offered as an expert witness. But I will agree with the legislative defendants' representations that in his role, Mr. Neesby certainly has a lot of firsthand knowledge, and perhaps the best firsthand knowledge in the state, at least within state government, about the matching analysis and the databases that are going to be discussed. So, he certainly could be asked about as a factual witness about these databases, about matching analyses that occurred in the past and that occurred under his watch under the current iteration of the voter ID bill. So, just to capitulate, we don't take a position on this particular exhibit, but we just want the court to be aware of sort of what this witness's role is, and both in state government and in the trial to understand the extent of his personal knowledge and how he can testify about the facts at issue.
Thank you. Mr. Giller, would you like to respond?
I'll respond briefly, Your Honor. To be clear, we are not seeking to exclude all the testimony of Brian Neesby. We understand that the role, as Mr. Cox laid out, that he is expected to provide for the legislative and state defendants. However, as I understand Ms. Morse's testimony, one of the things that they want to use this affidavit for is to opine on the match analysis that Kevin Quinn used and sufficiently what he did or didn't have access to or didn't do appropriately. And plaintiffs contend that any sort of analysis of the matching analysis such as that, and which is what the affidavit specifically does, is an improper expert testimony. And I would also say that at no point during his deposition did we rely on this affidavit. And we had, again, no idea or belief that that testimony from that affidavit would be elicited until yesterday. And I agree, it is a JX exhibit, and the reason it is a JX exhibit is because Dr. Thornton relies upon it, as we have discussed previously, I believe, last week.
Okay, give me just 1 minute, please.
And we do have, again, a motion we can deliver to the court if that would make it easier.
Okay, hold on just 1 second.
Of course.
Yes, Mr. Giller, go ahead and send the motion in. And one issue with that is how soon today he would be testifying. We would like to read the motion that you prepared. And I don't know if there are other areas that he could testify to besides this one specific area that we could get into without ruling on it. But we would like to read the motion, and then we may actually go into chambers and talk about it ourselves, the judges, before we give you a full ruling on it. But if you want to submit that motion to the judicial fellows, probably Adam Steele, I know that you all have communicated with him. He might be the best one to forward it to us. Okay.
Yes, Your Honors, we'll do that right away.
All right. And we also, I don't know if legislative defendants have anything in writing that you'd like to submit, but you'd be welcome to submit something as well. Again, I don't know how soon today he would be testifying, but I guess time is a little bit sensitive there. And if you need more time to submit something in writing, we potentially give you more time. It may mean a delay, but you know, it'll be what it's going to be. What is your, I know we've got Professor Hood on the stand right now, and I think, Mr. Giller, we're in the middle of your cross-examination of him. Is that right?
Yes, Your Honor.
Okay, so would Mr. Neesby be the legislative defendant's next witness?
No, Your Honor. The next witness will be Dr. Janet Thornton, but I think it's quite likely that Mr. Neesby in the normal course would start this afternoon. That obviously depends on the length of the cross-examination, but that would be my best guess.
Okay, well, let's go forward with that plan, and we'll consider the plaintiff's motion, and we'll consider any written response that the legislative defendants would like to submit, and then we'll go as far as we can, and even into the perhaps direct examination of Mr. Neesby. But when there arises a point within which the plaintiffs would object, maybe we'll stop there and see where we're at. So we'll just sort of play that by ear if that's okay to proceed in that fashion. Does that plan sound workable to you all?
Yes, thank you, Your Honor.
Yes, Your Honor, and we do plan to file a written response. We haven't seen this motion, so we don't know how long it will take us to respond to it, but when we get it, we will start working on a written response.
Okay, Ms. Riggs, if you want to go ahead and get that motion out, that'd probably be a good idea.
We'll have it to you momentarily, Your Honors.
All right, thank you. Anything else before we resume the testimony of Mr. Hood?
Not for the legislative defendants, Your Honor.
Okay, can we let Mr. Hood into the courtroom then? Professor Hood, can you hear me okay? Professor Hood, can you hear me okay?
Yes, Your Honor.
Okay, great. Good morning to you, sir.
Good morning, Your Honor.
Are you ready to resume your testimony this morning?
I am ready, Your Honor.
Mr. Giller, are you ready to proceed?
Yes, Your Honor.
All right, then you may ask your next question of this witness.
Professor Hood, nice to see you again. How are you doing?
Fine. Hope you're doing well.
Thank you. Professor Hood, just as a brief recap, I believe you testified on direct and yesterday, on Friday, that the lessons from implementation of the South Carolina voter ID law can be applied to North Carolina and inform what might happen if SB 824 were implemented in North Carolina. Is that accurate?
Yes, that's my opinion.
Okay. And your analysis of the South Carolina voting statute, just so we're sort of clear, is encompassed by the Palmetto study that you attached to your expert report. Is that correct?
Yes, that's fair.
And the Palmetto study is a single state study.
That's correct.
Okay. I think we looked at this on Friday, but just reorientated us again. Can we please put up JX39 at PDF page 43? This is the Palmetto postmortem. I believe it's page 10. And this is your report, the Palmetto postmortem, correct, Professor Hood?
Correct.
Okay. And if we look at the second paragraph, I guess, on the sort of top, it reads, to what degree are our findings generalizable, that's not right, to states outside of South Carolina? We would argue for the necessity of rigorous within-state testing in other contexts to determine if similar conclusions can be drawn. As mentioned earlier, although one can categorize voter ID statutes, e.g. states that require government-issued photo ID, there remain important differences between these laws across states. Is that accurate?
Yes.
Okay. And just so I'm clear, you didn't conduct any rigorous testing of the application or photo ID laws in North Carolina. Is that correct?
Well, that's correct. And to be fair, SB 824 has not been implemented.
Correct. But HB 589 had been implemented for one election, correct?
For a primary election, that's correct.
And you didn't do any testing or analysis of the effects of HB 589 for that primary election it was in effect for.
That is correct.
And you did, though, but in your report, you draw instead generalized conclusions from South Carolina or the effect of the South Carolina voter ID law and apply those to North Carolina, correct?
That's correct.
And just to confirm, you didn't design any survey to measure the likelihood that the results you observed in South Carolina would apply to North Carolina, did you?
I did not.
And you're not aware of any other studies that measure the likelihood that turnout results would apply for our state?
Turnout results from South Carolina to North Carolina? Is that what you're asking?
Yes.
No.
And you didn't consider the relative population sizes of North and South Carolina to be an important comparison point when you did your analysis. Is that right?
Correct.
And you didn't consider relative median income of North and South Carolina as a factor to analyze.
Correct. I mean, again, I didn't conduct a study of SB 824, as we talked about, or HB 589.
And you also didn't consider the relative median age of registered voters in North and South Carolina.
Correct.
And I believe you testified on direct that the fact that North and South Carolina both have very large minority populations, especially African-American populations, made comparing the states an apt comparison. Is that correct?
Well, it certainly makes it closer than comparing North Carolina to say, South Dakota, for instance.
But you didn't explicitly analyze or mention in your report the fact that they had similar racial demographics.
I don't believe so directly, no.
And you also, I believe, testified in direct the fact that North and South Carolina are geographically contiguous made comparing the two states an apt comparison. Do you recall saying that?
Yes.
You don't mention in your report or do any analysis determining that the fact that is a factor or something that you analyze in your report.
That's correct.
Is it fair to say that you had no metric to determine how similar North and South Carolina were before you drew your conclusions about the likely effect on turnout of SB 824?
Well, the metric I was using primarily were the laws that are passed in South Carolina and North Carolina. So that's a metric I was using.
Right. So your analysis focuses solely on the similarities between the actual North and South Carolina statutes.
In the report, yes.
Okay. And the report is all you're testifying to. I mean, that's your testimony today.
That's fair. Yes.
And so I guess just to sort of confirm, since you based your analysis on the statutes, it's not based on a comprehensive analysis of North Carolina itself.
That's correct.
No further questions at this time.
All right. Are there redirect questions from the legislative defendants? Well, I see Mr. Cox. Forgive me. You haven't had a chance to cross-examine this witness yet, have you?
That's all right. We can make it easy. I don't have any questions, Your Honor.
Okay, great. Then are there redirect questions for the legislative defendants as to this witness? Ms. Moss?
My apologies, I was on mute. Yes, I do have some redirect questions, Your Honor.
Okay, you may proceed.
Thank you. Good morning, Professor Hood. To your knowledge, was Senate Bill 824 based on South Carolina law, or was it based on House Bill 589?
Well, to my knowledge, it was based on South Carolina's Act R54.
And is that the law that you studied and analyzed in your Palmetto study that Mr. Giller was asking you about?
Yes.
Professor Hood, does your prior research experience, education, and training in Southern politics and general knowledge of North and South Carolina inform the opinions that you offered in your report in this case?
Yes, they do.
Okay.
Or yes, it does, I should say.
Okay. And why is it reasonable to rely on your study of South Carolina's voter ID law to conclude that Senate Bill 824 likely will not have a racially disparate impact on voter turnout, such as you found when you studied South Carolina's law?
Well, again, I made the argument in writing and in court that I believe Act R54, South Carolina's voter ID law, is very similar to SB 824 in North Carolina. We know as well SB 824 has not been implemented. Obviously, it's enjoined. It could be studied if the implementation was lifted and an election had occurred or were to occur. But in the meantime, given that the laws are very similar, again, one of the few things we can do to study the impact or the potential impact of a law in another state is to look at a law in another state that's been implemented and study the effects there and make an application. So that's what I've tried to do.
Okay. And without having done the various types of granular investigations that Mr. Giller asked you about, such as studying ID possession rates or how counties will spend appropriation, or how the specific training will be conducted, are you still comfortable pointing to the various aspects of Senate Bill 824 that you identified as mitigating factors that will reduce any potential impact that North Carolina's voter ID law will have on voter impact? Or I'm sorry, voter turnout?
I am. In fact, if you look, the two laws, again, big picture view, very similar. They both require the presentation of government issued photo identification, and they both have a reasonable impediment, either declaration or affidavit, depending on what state you're talking about, sort of an override to that. If anything, North Carolina's law is a little more lenient even than South Carolina's laws in terms of the mix of IDs that are available to be utilized in North Carolina compared to South Carolina. It's larger, as we talked about. As well, again, my understanding of the manner in which the reasonable impediment declaration would be implemented if the law were allowed to go into effect in North Carolina itself is a little more lenient than in South Carolina. In South Carolina, if you have a reasonable impediment to obtaining an ID, you can issue a declaration or an affidavit there, excuse me, cast a ballot. The ballot will be converted to a regular ballot without any other work on the part of the voter, as long as the declaration or the affidavit was issued and it was believed to be true, so not false. So in North Carolina, sort of circling back, it's my understanding, at least, that not only can you use a reasonable impediment declaration if you had difficulty in obtaining an ID, but also if you had difficulty presenting an ID. So you had an ID, but you showed up to the polls. In that case, you could also issue or execute a reasonable impediment declaration. In South Carolina, again, my understanding, and when I did the study, certainly it seemed to be the case that if someone has an ID, forgot it, shows up at the polls, that's not a reason in South Carolina, according to my understanding, to execute a reasonable impediment affidavit. You'd have to just vote a provisional ballot and then bring your ID later before the county canvass occurred. So so circling way back around to answer your question, yes, I believe that any potential negative effects of North Carolina's voter ID law, SB 824, would be mitigated by the things that we've been talking about, especially the free ID program and the reasonable impediment declaration.
Do you recall being asked on cross-examination about your statement that training is important to ensure uniform implementation of the law?
Yes, and I believe that to be the case.
Okay. And I believe you agreed it's preferable to have standardized training across the state. Do I have that correct?
That's my opinion. Again, training standards, again, if the law were to be implemented, training standards should be developed by the State Board of Elections in North Carolina and then disseminated to the counties.
Okay. And do you have any reason to believe that that is not what will occur?
Not sitting here today, no.
And do you know, does having standardized training mean that the State Board of Elections has to itself train every single poll worker across the state in order to achieve the kind of standardization that you believe is important?
Well, that's how I would, mandate that it be carried out if I were in charge. I'm not in charge, obviously. But that's one way to help ensure standardization of the process, the training process.
You were also asked on cross about the fact that South Carolina, prior to implementing its voter photo ID law, required voters to bring some form of identification, whether it was a photo ID or not, to the polls to vote. Does the fact that there was that requirement in any way change your conclusion about the effect of South Carolina's voter ID law on turnout?
No, voters were used to, I guess, the fact they had to bring something to the polls, but that went from a pretty expansive list of photo and non-photo identification to 5 forms of government issued photo identification beginning in 2014, or technically January of 2013 is when the law was implemented. So there's still an adjustment there for voters, if you will.
And you were asked on cross about why you didn't analyze and review voter turnout from the 2008 and the 2016 elections. Do you recall that line of questions?
Yes, I'm trying to remember exactly. Could you remind me exactly? I've executed multiple studies, whether it was related to South Carolina.
Sure. So I believe on cross, you were asked about the reason why you looked at voter turnout in an off presidential election year in 2014. So why you looked at why you didn't study voter turnout for a presidential election year. Do you recall that line of questions?
Okay. Yes. So this was related to the South Carolina study. Again, the
Yes.
answer is fairly straightforward. The law was implemented or put in place in South Carolina in January 2013. The 2 most proximate federal election cycles are obviously 2010 and 2014. And you want, in my opinion, to incorporate the two closest election cycles, pre-implementation and post-implementation. And we also had a no-match list that had been generated by the South Carolina Board of Elections, or excuse me, the South Carolina Election Commission. And again, the further you get away from when that no-match list was run, the less accurate it's going to be. So if you expand out to 2 federal election cycles, again, on the other side of that, say 2008 and 2016, then you're, the time gap is obviously increasing. So if you're looking for effects from a particular law, it's important, in my opinion, to hone in on the time periods closest to when the law was implemented, both pre and post. So that's the answer.
And do you recall being asked on cross-examination regarding your South Carolina study about whether you took into account the candidates that were running in those elections or the get out the vote efforts that might have been undertaken in those elections?
Yes, I do.
Does your study design that you used for your South Carolina study require you to take those factors into account to test the hypothesis that you had set forth at the beginning of your study?
Not explicitly, no. And again, to some degree, the research design, the difference in difference design that we use captures overall campaign effects. In other words, we can control for, look at turnout in a particular election cycle compared to another election cycle. And the idea is that everyone in those election cycles are being exposed to the same campaign stimuli, if you will. So, and for instance, and we saw this, you can see this in the study, in 2010, elections were more competitive at the statewide level. In South Carolina, turnout was a little bit higher. In 2014, elections were less competitive. We had a bunch of incumbents running for re-election. Again, the polls weren't very close. Turnout drops. So you can the design to some degree controls for that overall. Again, you don't have to test for things specifically within that context.
And what does it mean that you were using a panel that looked at the exact same voters in 2010 and 2014?
Well, again, this was an academic article. Some of what we did was in response to anonymous reviewers that were asking us to look at different research designs and setups. And, a lot of times anonymous reviewers give very good advice. I mean, that's the whole purpose of the peer review process. And so so a panel would be someone is present in 2010 in our study. To be eligible to stay in, they'd have to also be present in 2014. So it's the exact same group of people you're tracking in 2010 and 2014. And the reason we set things to a panel again was in response to advice by anonymous reviewers. And the reason I subset it even further to include active registrants, which was again a question that came up, goes back to table 1 in the article. And again, what we're trying to do, these voter registration databases, as we all know, are moving targets. They change sometimes daily, but they certainly change weekly. So we have sort of snapshots. I don't have every database across these time periods. No one does except the state. So we're taking a snapshot. So I'm trying to ensure that the snapshot that we have looks like the electorate at that point in time. And reducing things down to active registrants gets us to table 1, where I do have some overall turnout and registration figures from the state of South Carolina that very closely match and therefore are congruent, hopefully, with the snapshots of the registration databases that we possessed. And so again, for reference, that's in table 1 of the article. And that's why we subset things to active registrants.
Now, do you recall being asked about a table that was appended to your report, table B?
Yes.
And, Ms. Hardiman, if we could pull that up, it's JX 39, and it's Table B of Professor Hood's Palmetto report that was attached to his expert report. Oh, I think, yes. If you could, can you see that on your screen, Professor Hood?
Yes, yes, and I have it in front of me. I have a hard copy in front of me.
Great, thank you. So you recall being asked about this table, is that right?
That is correct, yes.
And as a refresher, since it's been since Friday when we discussed this last, what does Table B show?
So table, I'm sorry, okay, Table B shows, again, a different model specification. And again, these were included with the article in an online appendix, which is a very common thing that occurs with academic articles nowadays. If you can't fit everything into the page constraints for the article, most publishers allow you to have an online appendix. So these are different model specifications that are in an appendix. And Table B is a difference in difference panel, again, panel estimate of the same thing that we saw previously in the article that includes active and inactive registrants, both.
Okay, so when you included active and inactive registrants in this one model that was a panel difference in difference, did you find that there was some slight difference between Black voter turnout and white voter turnout?
Yes, I did.
And what was that difference?
0.2.
Okay. If we can now look at panel C, which is the next, or I'm sorry, panel Table C, which is the next page of your report.
Okay. So this is, again, an additional model specification. These models are very sensitive, if you will, to how things are set up. And so we wanted to present, different ways of setting up these models. So Table C is the difference in difference design that includes active and inactive registrants that are not in a panel set. So in other words, we have the voter registration database in 2010. So everyone in the database, active and inactive. And we have a copy of the voter registration database in 2014, everyone in the database, active and inactive. And so this is the same test exactly run on that group of people. So it's a slightly different group of people.
And the same test that you ran for Table B that we were just looking at?
Table B and also Table 4, I believe, in the original article. Yeah.
Okay. So under this model, as referenced in Table C, what did you find in terms of the difference between voter turnout for Black and white registrants?
Well, this is interesting because actually there's a plus sign here instead of a negative sign. So that means that the intra-election difference, the turnout difference between those with and without ID from 2010 to 2014 narrows. So for instance, if you look at the top panel there, or the top row where it says all registrants, the intra-election turnout difference goes from 33.7 pre-implementation to 31.8 post-implementation. So this test actually predicts that there's a positive effect with implementation of South Carolina's voter ID law on turnout by reducing that intra-election turnout gap. And then again, subset for white registrants and Black registrants. For white registrants, it's plus 1.0, and for Black registrants, it's plus 1.9. So in this model configuration, you certainly can't find evidence, again, that there's a negative or depressive effect. It's actually a positive effect.
Okay. And then finally, turning to table D, which is the next page, what did this model look at?
Very similar. Again, it's the same test. Now here we're looking at just active registrants. So all active registrants in our copy of the 2010 voter registration database, all active registrants in the 2014 copy of the voter registration database. So that's not a panel again. And again, we see the same positive effect. So a plus 3.6 overall, plus 2.6 for white registrants, and plus 3.6 for black registrants. Now, this may seem counterintuitive. Again, we presented in the article, inside the body of the article, what we thought were the most conservative tests of South Carolina's voter ID law. These are other specifications. It may seem sort of counterintuitive a little bit. And again, I'm not arguing these are the most conservative specifications, but how could you have a positive effect? There has actually been academic research that shows that after passage of a voter ID law in some states, that efforts, get out the vote efforts, education efforts on the part of the state, efforts on the part of third-party groups to get people free IDs, and as well anger on the part of certain groups over passage of the voter ID can actually have a positive effect. Now, again, I'm not arguing that this is the most conservative test. Again, we believe we included that in the body of the argument. The body of the article, sorry. But again, these alternative model specifications were all made available with the article when it was published.
Understood. And so, again, understanding that you picked what you believe was the most conservative one to focus on in the article, of the alternative model specifications that you appended to the report, am I right that 2 out of 3 of them showed a positive impact on African American turnout, and the one that plaintiff's counsel focused on showed a 0.02 negative impact?
That's correct. So of the 4 specifications, including the one originally in the article, 3 out of 4 of those show essentially no racially disparate impact, I guess is another way to sort of summarize things.
Okay. I now would like to turn to table 7 in your article, which is on page 9 of the article itself. Do you recall being asked about this table on cross-examination, Professor Hood?
Yes.
Okay. And I believe you described this as a counterfactual. Can you explain for us what it means that this is a counterfactual?
Well, a counterfactual is when we take known information and then make certain assumptions about other factors and essentially try to rerun history in a way in which it didn't occur. Now, again, as I state in the article itself in a footnote, typically in a court case, we don't present counterfactual information. In a court case, information about testing typically stops with, an analysis of rates or ratios, for instance, of voter turnout by race, for instance. So this goes a little bit beyond that. Again, this was in response to an anonymous reviewer that asked us to do this, so we did this.
And can you tell us what is the counterfactual that you were hypothesizing here?
Well, the major assumption we're making here, which is a little bit of a heroic assumption, really, is that the turnout rate for those without ID in 2014 would have been the same as it was in 2010. It's a little heroic because even for those with ID, we see turnout drop between 2010 and 2014 in South Carolina. It just does. But we say, well, what would happen if the turnout rate for that group of individuals that we think don't have an ID stayed the same in 2014 as it had been in 2010? So This is, if, and then we can through some mathematics, really simple math, we can come up with a counterfactual turnout rate. Okay. And so that's how we get down to the bottom of this, where we think, for all registrants that, at most, again, under this counterfactual, the turnout rate due to the law, due to the implementation of the law, may have dropped by 0.19% or less than 0.2 of a percentage point.
And when you broke that down by race, what was the difference between the decrease in white versus black turnout that this counterfactual?
So for whites, the decrease was estimated, again, under this counterfactual, to be negative 0.19, and for African Americans, negative 0.25. So that would be what, negative 0.06% difference between those two.
And is a 0.6% difference considered statistically significant?
Again, I guess this is we're at a point here where Professor Quinn and I may differ on this. I've got the confidence intervals located around those estimates, and they do touch. He says he makes the case that it's statistically significant. Again, at this point, whether it's statistically significant or not, we're talking about a very small difference. And again, it's up to the court, not me, to determine whether or not the difference in this counterfactual is substantively significant, not just statistically significant. And again, that's not up to me to judge.
And do you recall being asked on cross-examination about whether you were criticizing various aspects of Professor Lolotis's report that you had not been asked to review and rebut?
Yes.
Does the fact that you're not offering opinions in rebuttal of his report mean that we can conclude that you're agreeing with the points and opinions that he makes, or that you're just not taking a position?
I'm just not taking a position. I wasn't asked to look at anything except the very specific claim that he made, and I did respond to that.
Okay. Do you also recall being asked by Mr. Giller about Professor Lolotis's bibliography and whether you had reviewed anything other than the article that he relied on for his point on voter turnout?
Yes.
Why didn't you review anything other than the article he cited related to voter turnout?
Well, the main reason is because I was asked by counsel to review that article specifically and the claim made by Professor Lolotis.
And again, the fact that you didn't review other articles not related to voter turnout, does that mean that you're taking a position one way or another on, on those points made by Professor Lolotis?
No, I'm not.
Well, thank you, Professor Hood. That's all I have for you for now.
Thank you.
All right. Is there further cross-examination, Mr. Giller?
Yes. I have a
All
couple brief questions, Professor Hood, if you have a second.
Of course.
Thank you.
I'm not doing anything else right now.
Professor Hood, I want to, if we could bring up your table C again, so there are a couple of quick questions about it. And I think what is that? That is toward the end. I think it's Ashley. Great. Professor Hood, I believe that on redirect, the council asked you a number of questions about this. This is from your Palmetto study, Table C, correct?
Correct.
And just to confirm, I believe you might have said this, but Table C is not a panel analysis, correct?
That is correct.
And Table B was a panel analysis.
That is correct.
So Table C doesn't track the same set of voters.
Not the exact same set of voters. I mean, there's obviously quite a large subset of those that are the same, but not all of them are the same. That's correct.
Great. So you would say that Table B and C is not an apples to apples comparison. Is that correct?
Correct. C and D are not panels. Table 4 and Table B, if I can keep everything straight, are panels.
Right. So just so the record's clear. So B and C is not an apples to apples comparison.
No, they're different groups.
Great. And Table C does not account for differences in the number of registered voters between 2014 and 2010 South Carolina. Is that correct?
Can you expand on that question? I don't know exactly what you're asking me.
Sure. So you're aware that there were nearly 250,000 more registered voters in South Carolina between 2014 and 2010, right?
The number of registrants increased. Yes, I couldn't tell you the exact number. But
Sure. If I represented it was around 250,000, does that sound right?
approximately, yes.
And I just want to confirm that that's not taken into account by your Table C.
Well, it would be taken into account in 2014, but not 2010, if that makes sense. I mean, someone that registered between 2010 and 2014 would be picked up in 2014, but they wouldn't be in 2010, right?
Right. But the change that you are reflecting here, that's another difference between that and Table B, which was a panel.
Well, right. I mean, that is the difference. I
Right.
mean, I think we're sort of talking around each other at this point. B is a panel, has exactly the same people in 2010 and 2014. C is not and does not have exactly the same people.
Great. Thank you, Professor Hood. We can take this down now. I believe Ms. Morris asked you a question about poll worker training on your redirect. I believe you said that, that standardization across the state was important, correct?
Yes,
And I believe that Ms. Morris asked that you have no reason to believe that the state would not attempt to achieve standardization, correct?
correct.
But you haven't done any analysis of any actual programs that the state plans to use to achieve the standardization that you think is important. Is that correct?
That's correct.
And you haven't reviewed any training manuals.
That's correct.
You haven't spoken to anybody at the state about how they plan to do their training.
Correct.
Okay. I believe you also referenced the reasonable impediment declarations as a mitigating event that North Carolina utilizes. Is that right?
Yes,
All right, but just to confirm, you haven't done any analysis of the use of reasonable impediment declarations in North Carolina, correct?
correct.
Okay. And I believe you had said before, but I just want to sort of clarify. Do you believe that in North Carolina, you can utilize a reasonable impediment declaration if you've forgotten your ID at home?
That's my understanding of how it hasn't been implemented, right? SB 824 has never been in effect.
I'd like to bring up JX 674, which is SB 824. So just to clarify for the record, Professor Hood, this is SB 824. You've reviewed this, correct?
Yes,
So if we go down to page 3, I think it's D1, bottom of page 3. And can you see this, Professor Hood? I want to make sure you can see that.
yes, I can.
And this is reasonable impediment declaration under D1. Is that correct?
Correct.
And it says the state board shall adopt a reasonable impediment declaration form that at a minimum includes the following as separate boxes they identify. And number one is inability to obtain photo ID due to, and then it lists all the possibilities, right?
Correct.
It says lack of transportation, disability or illness, lack of birth certificate, work schedule, family responsibilities, correct?
Correct.
And then B says lost or stolen photo ID.
Correct.
And then C says photo ID applied for but not yet received.
Correct.
So none of those, though, say left ID at home, right?
That's correct.
Okay. So based on a pure reading of this, you would agree that there is no actual box for left ID at home.
Correct.
Okay. And I believe you had said earlier that you had done, and we can bring this down, that we had done an analysis of the statutes in North Carolina and South Carolina. Is that correct?
Yes.
Okay, but just to sort of be clear for the record, you didn't do an analysis of turnout in North Carolina. Is that right?
Correct. That's correct.
Right. And you didn't do an analysis of any racial disparities in North Carolina.
Correct.
You didn't do any analysis of any North Carolina specific factors, the same way you did in South Carolina.
Correct.
No further questions.
Mr. Cox, do you have any questions?
No, thank you, Your Honor.
Ms. Moss, do you have any more questions?
Nothing further, Your Honor.
All right, we may have a question or two from the court. So I think Judge Rozier, if you want to take the floor.
Yes, and first, do you prefer doctorhood or professorhood? I know some people have.
It doesn't really matter, Your Honor. Whatever you'd like to call me.
Okay, I'll go on doctorhood. I'll just go back to your Palmetto study. I think that's primarily where my questions will come. I look, and you referenced it on Friday, but just going back to between 1950 and 1970, South Carolina was the only state to require voter ID, and then Hawaii did so, and then 14 other states with non-photo identification as a requirement before the other states added theirs. I'm reading from the second page.
Yes.
Are you familiar with whether or not any of those additional states did so following the passage of a constitutional amendment?
Well, this is from my memory. I don't think so. But I'm not 100% certain on that. I think most of it was statutory law.
All right, thank you. The other question is just in regards to the timing of your study. And I just want to seek clarification to make sure I'm reading it correctly. This was published in the Quarterly Journal in 2019, correct?
Yes, sir.
Do you recall which quarter that was? I see I-14. I don't know if that means it was the first quarter, but I see 14, so that throws me off a little.
I do not know for certain, Your Honor. It looks like it's the second number of that volume. So maybe, but I don't know. It's possible it was sort of second quarter of that year.
Okay. And prior to the publication of your study, do you recall sharing any of the findings with someone other than Mr. Buchanan? It seems like it would be anticlimactic if you told everyone what the results were before you published it, but just ask.
I don't know. I don't remember doing that. I mean, I think this was presented, or part of this was presented as a conference presentation, which is very common for academics to present work before it's been published at academic conferences. So I do believe that occurred, but I don't think we shared the results, the final results, with anyone until after it was published.
All right. So that would have been in 2019 sometime, I guess.
Yes.
And then the next question, maybe the last one, is I see your two hypotheses. Well, I know there's sometimes to play on words like with your title from the Georgia study, which was just more clever. With the hypothesis, though, I'm assuming that this was what you expected the evidence to support whenever you originally came up with the hypothesis.
Not necessarily. You can put forth a hypothesis, and then it can be proven or disproven. It doesn't really matter. It's what the data and the tests tell you. If that makes sense, Your Honor.
Yes,
And can I say one other thing about the publication? So I think this came out in print in 2019. I think it came out. All of these articles nowadays are released electronically before they ever come out in print. So it probably, if I could look, it probably came out in 2018, electronically speaking.
Okay. And then just going back, thank you for that clarification. And going back to your hypothesis, I guess the natural question then becomes, if you had to choose one way or the other, was there some particular reason that you phrased or framed the hypothesis this way in comparison to the alternative? If what you were doing was seeking that, it's not a gotcha question. I'm really just trying to understand.
Well, honestly, again, most of the theory would point to voter ID laws as, if anything, having a depressive impact on turnout. So that's really the reason why these hypotheses are phrased this way. And then we go and collect data, analyze the data, and determine or try to make a determination whether the hypothesis can be upheld or not, accepted or rejected. So that's why they're sort of phrased in a negative sense, if you will.
All right. I think those are my questions, Dr. Hood.
Thank you, Your Honor.
Okay, give me just 1 second. Are there other questions based on the court's questions from any of the attorneys handling Professor Hood's testimony?
None from legislative defendants, Your Honor.
None from the state defendants.
None from plaintiffs, Your Honor.
Okay, Professor Hood, thank you very much for being here and your testimony, sir. You're now free to leave the virtual courtroom.
Thank you, Your Honor.
All right, Mr. Thompson, are you ready to call the legislative defendant's next witness?
Yes, Your Honor. The legislative defendants call Dr. Janet Thornton to the stand, and Mr. Patterson will be handling the direct examination.
All right, Janet Thornton can go ahead and be allowed to come in the courtroom. Who will be handling this witness on behalf of plaintiffs?
Your Honor, this is Allison Riggs. I'll be handling the cross.
Thank you, Mr. Riggs. And for the state defendants?
Paul Cox, Your Honor.
All right, thank you, Mr. Cox. Can Janet Thornton hear me?
Yes, Your Honor.
Good morning, Ms. Thornton. How are you?
I'm fine, thank you. How are you?
I'm doing well. I can hear you. I can hear you fine as well. Are you ready to give your testimony in this case?
I believe so.
All right. If you would, please raise your right hand. Madam Clerk.
You solemnly affirm that your testimony to the court will be the truth, the whole truth, and nothing but the truth, and this is your solemn affirmation?
Yes.
Thank you. You can lower your hand.
Mr. Patterson, you may proceed with your examination of this witness.
Thank you, Your Honor. For the record, this is Pete Patterson to the legislative defendants. Good morning, Dr. Thornton.
Good morning.
Thank you for joining us today. To get started, I'd like to ask some questions about your background and experience. Could you tell the court what degrees you hold?
Yes, I have a doctorate and a master's degree in economics from Florida State University. And I have a bachelor's degree in economics and political science from the University of Central Florida.
Okay, thank you. And where are you currently employed?
I am currently employed by Berkeley Research Group.
And what type of work do you do at the research group?
Well, I work as an economist and applied statistician to answer questions and research questions, some arising from litigation and some arising to assess risk. So organizations will ask me to prepare statistical analysis for risk assessment.
And how long have you been with the Berkeley Research Group?
Since 2015.
And where did you work before 2015?
Prior to working at BRG, I was employed by Economic Research Services.
And what did you do for Economic Research Services?
I did the same thing. I was employed there for nearly 30 years.
Okay. And are you a member of any professional associations?
Yes, I am a member of the American Economic Association, and I'm also a member of the National Association of Forensic Economics.
And what experience, if any, do you have in matters involving allegations of discrimination on the basis of race?
Since I first started working professionally, I have prepared hundreds, if not thousands, of analyses regarding allegations of discrimination, some involving allegations in employment, some and that would include pay equity, some involving voting rights, and others involving housing and lending.
And you
the
meant
allegations have been involving claims of discrimination with respect to gender, race, ethnicity, age, pregnancy, and religion.
And you mentioned voting rights. What is the extent of your experience in matters concerning elections and voting rights?
I've been retained to prepare statistical analysis involving different voting rights questions, some involving the voter ID, some involving provisional ballots or voting, among others. I was retained in the matter of Lee versus the Virginia State Board of Elections with regards to their voter ID.
And what experience, if any, do you have working with large data sets?
A lot of experience going back to my graduate school days in the early 1980s. I've worked with many, many data sets. I've worked with some that included billions of records or entries that involved matching.
And have you linked large data sets with DMV files before?
Yes, I have.
And approximately how many times have you done that?
In the course of my tenure, probably 5 to 10.
And have you published scholarly articles in your field?
Yes.
And have you taught college courses in your field?
Yes, I've taught courses in statistics, quantitative methods, as well as courses in economics.
And approximately how often have you participated as an expert in litigation?
Probably at least 100 times.
To your knowledge, has any court ever excluded your testimony as an expert?
Not to my knowledge.
Your Honors, we proffer Dr. Janet Thornton as an expert in quantitative methods and statistics.
No objections, Your Honor.
Objection.
All right, she is so received.
Okay, well, to get started here, I'd like to bring up JX59, and this is affidavit of Dr. Janet Thornton from June 18th, 2019. Dr. Thornton, is this the rebuttal report you submitted at the preliminary injunction phase of this case?
Yes.
And broadly, what issues did you address in this report?
I addressed the assertion by Dr. Quinn that he made in his PI report that the additional forms of voter ID that arose from Senate Bill 824 that were not part of HB 589 would not narrow the gap between by race in terms of voter ID possession. So his claim was that these additional forms would not make a difference, and I addressed his claim.
And again, at a high level, what conclusions did you draw in addressing his claim?
So I found that the opposite was likely, and I did so by looking at the racial composition of those who were likely to have a college student ID, as well as those that were likely to have a state or local government ID. And I did this by actually looking at the data that were publicly available with regards to college student IDs, as well as government IDs, in which I learned that the percent African American is higher among those ID or potential ID possessions. And so I concluded that they would perhaps and likely reduce the gap.
Okay, and now I'd like to bring up JX800, and this is your January 20th, 2021 rebuttal report. And this is the rebuttal report you submitted at the merits stage of this case, correct?
That is correct.
And broadly, what did you consider in your merits rebuttal report?
And for the rebuttal report, I looked at the 480,000 no matches identified by Dr. Quinn. I also examined his sensitivity analysis, and I also looked at the composition of those who utilize early voting.
And what conclusions did you draw, again, at a high level in this report?
Well, I concluded that with the additional forms of ID, that the gap, as measured by Dr. Quinn, had been reduced between his 2015 report and his 2020 report. I also found that there were forms of ID that he did not use and or did not discuss that would impact his sensitivity analysis. And finally, I found that early voting or one-stop absentee voting is the most prominent or most utilized form of voting in North Carolina, and that African Americans utilize that form more so than other racial or ethnic groups.
And do these two reports we just discussed represent the expert testimony that you intend to provide in this case?
Yes.
Your Honors, we move into evidence JX59 and JX800, which are the reports that Dr. Thornton has submitted in this case, and ask that they be treated as her direct testimony for the stipulation of the parties.
No objection, Your Honor.
JX59 and JX800 are received.
Thank you, Your Honor. Dr. Thornton, as you mentioned, you evaluated the matching analysis that Professor Kevin Quinn submitted in this case, correct?
That's correct.
And we've brought up on the screen here LX 183, and this is a demonstrative that we've put together reflecting the results that Professor Quinn obtained in that matching analysis. How would you describe the difference in the overall no match percentage between African American and white voters that Professor Quinn found?
The percent of African Americans that Dr. Quinn identified as not having a match, meaning based on his matching algorithm, he did not find a match for a group. That percentage is 7.61%. As compared to whites, he calculates that 5.47% lack an ID. The difference between the 7.61 percentage and the 5.47 percentage is 2.14 percentage points. So to the extent there's a gap, as Dr. Quinn has measured it, the gap is 2.14 percentage points.
Okay, and now I'd like to bring up PDX4 and go to slide 5. And this is a demonstrative that was used by the plaintiffs during Dr. Quinn's testimony. And the heading on this demonstrative says, registered Black voters are 1.3 times more likely to lack qualifying voter ID than registered white voters. Is this consistent with how Dr. Quinn's findings are presented in his report?
Yes, in terms of the 1.39.
And what is your opinion about Dr. Quinn's presentation of his findings in this manner?
I find this demonstrative to be misleading. If I looked at this demonstrative, it would suggest that if I look at the number of rows, it would look as though 40% of white voters lack an ID, and it would look like 55 to 60% of Black voters lack an ID. And as I already testified about, those are not the percentages, but this demonstrative gives you that impression.
And when you're dealing with percentages, what is the effect of dividing two percentages by one another as you move toward zero for the same percentage gap?
It can make a percentage gap, as we have here, 2.14 percentage points, to appear to be larger by saying, oh, they're 1.39 times. The way in which Dr. Quinn calculates the 1.39 is he takes the 7.61% that he calculated for African Americans, and he merely divides it by the percent that he calculated for whites, which was the 5.47%. You divide the two, and you have 1.39. That's how he calculates his 1.39 times. But the percentage difference, it's 2.14 percentage points. But you can make it look much bigger than it is by dividing the two numbers.
Okay, and now let's look at back at LX 183. And this is the chart that we had created, the demonstrative chart that we have created. And in this chart, in the ratio W over AA, which is white over African American column, we have simply flipped Dr. Quinn's analysis and created a ratio by dividing the percentage of whites who have ID by the percentage of African Americans who have ID. What does this calculation show, and what does that say about the way Dr. Quinn presented his results?
Well, here, if you use the possession rate of white to African American, the ratio is 1.023, so nearly 1. So a ratio of 1 means that they're nearly identical. Keeping in mind here, we have a 2.14 percentage point difference. So consequently, if it's that small, relatively speaking, you flip and look at a different ratio, you'll have a different conclusion. And to just describe a little bit further how taking the ratio influences the outcome. As I've said many times now, here we have Dr. Quinn calculates a 2.14 percentage point difference. But suppose he hypothetically had calculated that 70.8% of African Americans lack an ID and 50.8% of whites lack an ID. So you have a 20 percentage point difference. If you take that ratio of 70.8 and divide by 50.8, you will have 1.39, the exact same ratio that he calculates when with the 2.14 percentage point difference. So by taking a ratio here, you can make a difference look large.
And now, back onto looking back at this chart that we've put together, we've also put Dr. Quinn's results for active voters, 2018 voters, and 2016 voters. How would you describe the percentage gap between African American and white voter presence on the no match list under these results compared to Dr. Quinn's overall no match list?
In each case, they have been reduced. So among active voters, the difference is reduced from 2.14 percentage points to 1.42 percentage points. And among the 2018 voters, it has been reduced, sorry, I'm having trouble reading, down to about 1.19 percentage points, and 2016, it's down to about 1.6 percentage points.
Okay, now I want to bring back up the Dr. Quinn demonstrative and go to PDX 4-6, which is the next page. And this says in the 2016 and 2018 elections, registered Black voters were 2 times more likely to lack qualifying ID. So how does Dr. Quinn make the smaller percentage gap among 2016 voters and the racial disparity appear to be a larger gap than he found in his overall results?
Sure, he does that again by calculating, taking the 2 percentages and dividing them by one another. So if you took the, for example, the 2016 or the 18 numbers, you divide one number, for example, 3.14 divided by the 1.13 or 14 number, which is about half. You divide one number by the other, you get 2. So he's able, by merely taking the percentage that he estimates among African Americans without an ID, among those who voted in 2016 or 2018, by the percentage white, divides one number by the other, and because one of those differences is half the other, he comes up with a ratio of 2.
And what is your opinion about Dr. Quinn's presentation of his results in this manner?
Well, again, it's misleading. When I look at this demonstrative, it appears to me he has registered white voters. It makes it appear as though 40% of white voters and 80% of African American voters lack an ID. And we know that's not the case. We know that the percentage is between 1 and 3 percentage points amongst these two groups.
Okay, now I'd like to bring up LX 254 which is a demonstrative that we've created to, in some way, redo Dr. Quinn's analysis. So if we look at this page right here that we're looking at, the heading says in the 2016 election, registered Black voters at 96.86% were 1.6% more likely to lack qualifying ID than registered white voters at 98.46%. Is that an accurate representation of Dr. Quinn's results?
Yes.
And then if we look at the shading in orange and gray, is that a more accurate representation of Professor Quinn's results than on the demonstrative that we just looked at?
Yes, it is.
Okay, and on the demonstrative that we just looked at, it was 2016 and 2018 voters. So I'd like to go to the next slide. And so this shows results for voters in the 2018 election. And it says in the 2018 election, registered Black voters at 97.67% were 1.19% more likely to lack qualifying ID than registered white voters at 98.86%. And then, again, is this an accurate way of conveying Dr. Quinn's results?
Yes.
And is the same the case for the orange and gray shading on this slide?
Yes, it is.
Okay, we can take that down now. Dr. Thornton, to what extent does Dr. Quinn establish that African American registered voters and white registered voters have an equal likelihood of being eligible North Carolina voters?
He does not.
And why is it significant that he does not do that?
Because here, when we look at individuals and look at mobility, based on mobility rates that we see alone, we would not expect there to be equal likelihood.
And what effect does Dr. Quinn's failure to establish that African American registered voters and white registered voters have an equal likelihood of being eligible North Carolina voters have on the validity of his results?
It has an impact, particularly here where we have a small percentage point difference. It means any slight deviation, that is, if there's other data or failing to take into account mobility, that may reduce that gap that he's measured.
Very good. Okay, if we could bring up JX 800, which is the rebuttal report you submitted at the merit stage of this case. And I'd like to go to table 2 on page 13, and it's up on the screen now. And the title of this table is Comparison of Distribution of No Matches, estimated by Dr. Quinn in 2015 and 2020, the distribution among registered voters. What is the significance of the data presented in this table?
And may I pull up my clean copy that I have here, because I have difficulty seeing.
Absolutely.
While she's doing that, let me go ahead and interject. It's now 11 o'clock and it's time for us to take our morning break. So we're going to take about a 15-minute recess at this point. We'll come back at 11:15. All right. So in recess till 11:15. Thank you.
Thank you.